Imagine this, you're standing on the deck of your $50 million yacht. The ocean breeze is perfect, the champagne is cold, and life feels untouchable. Then your phone buzzes, it's your attorney. Someone just filed a lawsuit against you, and here's the kicker. Your yacht is the first thing they're coming after. Why? Because luxury assets like yachts, jets, and art collections are lawsuit magnets. They're flashy, easy to trace, and they scream deep pockets to opposing attorneys. So stay with me because in this video, I'll reveal why luxury assets are the easiest targets in court, how billionaires shield them, and how you can too. I'll also share real cases where opportunities sank faster than a yacht with a hole in the hull, and the exact structures my law firm uses to make sure our clients don't end up as someone else's payday. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. For 34 years, I've helped high net worth individuals protect everything from real estate portfolios to stock market investments to $50 million yachts. In fact, my firm has set up more Cook Islands trusts than any company in the world, and I've been setting them up for nearly 30 years. So if you want insider strategies that the ultra wealthy use, but almost nobody talks about, hit subscribe now if you haven't. That way, you'll always know how to lawsuit-proof your lifestyle. Now, let's be blunt. If you own a yacht, a jet, or a mansion, you're a walking lawsuit target. Plaintiffs' attorneys don't just sue to win, they sue to collect. And to be clear, this video isn't just about yachts. It's about protecting what's yours no matter what you have. We're just using yachts as an analogy to whatever asset you need to protect. Now, here's why luxury assets in particular are so vulnerable. Visibility. Your yacht's registry is public. That private jet, it's tracked every time it takes off and lands. Your art collections, it's in catalogs, charity events, and insurance filings. Liquidity value, unlike your family home, which may have some statutory protections, luxury assets often have little or no automatic shield. Judges see them as fair game. Perception, to a jury, a yacht screams excess, and that makes it easier for the other side to argue that you should pay big. Cliffhanger. Later in this video, I'll tell you about a real case where a business owner lost his yacht, his jet, and nearly his company, all because of one overlooked protection step. Okay, since we're on the topic, let's zero in on yachts. If your yacht, or luxury car for that matter, is titled to your personal name, congratulations, you've just painted a bullseye on your back. Plaintiff's attorneys can file what's called a writ of execution, and that allows the sheriff to literally seize and sell your yacht, auction it to satisfy a judgment, and leave you high and dry. Even if you finance the yacht, the equity you do have could be stripped. And trust me, there's always a buyer for a discounted yacht. Case in point, a Florida medical professional was sued for malpractice. He thought his $7 million yacht was safe because it was insured. The creditor still seized it, sold it, and pocketed nearly $2 million in equity. That yacht was gone in weeks, and here's the kicker. The yacht wasn't even related to the lawsuit. It was just an easy, high-value target. Now, yachts aren't alone in this. Private jets are equally vulnerable. Registration is public. Hangar space is obvious, and values are high. Art collections, same deal. That Picasso on your wall isn't just admired by guests, it's admired by creditors too. Courts love art because it's portable, valuable, and easy to sell. And don't get me started on exotic cars. Lamborghinis, Ferraris, Bugattis, they're rolling billboards saying sue me. Now here's a wild stat. According to the American Bar Association, nearly 79% of high net worth individuals will face a lawsuit in their lifetime. If you're displaying visible wealth, your odds aren't just high, they're guaranteed. So how do billionaires keep their yachts from being hauled off to the auction? They use layers of legal firewalls. Here's a typical billionaire playbook that we employ for our high net worth clients. Title in an LLC, never personal name. Instead, the yacht's owned by an LLC, sometimes even a foreign LLC. LLC inside of a trust. The LLC itself is placed inside of a Cook Islands trust. That's the nuclear shield. Equity stripping, a line of credit recorded against the asset. payable to another offshore LLC in the trust. That way, even if somebody tries to seize it, there's no equity left to grab. And then if needed, we get a third-party lender to purchase the lien and put the proceeds into an offshore asset protection trust. And here's where my firm comes in. When we set up a Cook Islands trust, we also set up a Cook Islands LLC inside of the trust. You, the client, manage the LLC day to day. The licensed bonded trustee company law firm only steps in if and only if a lawsuit strikes. That means you maintain control in calm waters, and then when the storm comes, you're legally protected. And in a moment, I'll explain why the Cook Islands specifically, not Switzerland, not the Bahamas, has been the courtroom fortress of choice for nearly 40 years. Let me share you a story. A California entrepreneur owned a thriving logistics company and a luxury lifestyle, yacht, jet, and vacation homes. He assumed his LLCs were enough. Then came a $15 million lawsuit. His attorneys argued, they delayed, but the court ruled against him. Within 6 months, his yacht was seized. His jet was grounded and sold. Worse, because his LLCs were U.S.-based and not insulated by a trust, creditors were able to pierce through and take business assets too. One overlooked offshore trust would have blocked the entire collection process. This isn't theory. This is what I've seen firsthand in the 34 years I've been in the asset protection industry. So why the Cook Islands? Because U.S. courts hate it, and that's a good thing. If a U.S. judge orders you to turn over your assets held in a Cook Islands trust, you legally can't. The trustee is offshore, outside the U.S. jurisdiction. Creditors have to start all over again in the Cook Islands and under Cook Islands laws. And those laws, brutal to creditors. They must prove beyond a reasonable doubt the highest legal standard that you set up the trust specifically to defraud that one creditor. Plus, they have to post tens of thousands or hundreds of thousands of dollars in non-refundable court fees or attorney's fees just to file the case. So that's why my firm has set up more Cook Islands trusts than any firm in the world. They work, period. Now, some people say, I'll just insure my yacht. Now, insurance is good for storms, theft, accidents, and so on, but insurance for your boat does nothing against lawsuits aimed at you personally. In other words, if your creditor wins a judgment, or if your judgment is higher than your insurance limits, or your insurance policy doesn't protect against your type of judgment, your insurance company won't step in to block asset seizure. It's like wearing a life vest on a sinking ship, but forgetting to patch the hole that's in the hull. You need the legal structure first. So here's the truth. Luxury assets are a lawsuit magnet. Yachts, jets, art, fancy cars, they're flashy, visible, and easy to seize, but they don't have to be your Achilles heel. With the right structures, LLCs, equity stripping, and especially a Cook Islands trust, you can keep your lifestyle intact while everyone else is scrambling in court. I'm the business guy, the CEO of the Lawyers Limited law firm and Asset Protection Planners. My firm and I have been protecting assets for over 3 decades, so if you own luxury assets or you plan to, feel free to go to assetprotectionplanners.com. You get a lot of free information there, and let's talk, because when the storm hits, it's not about how beautiful your yacht is, it's about whether or not it's still yours.